like a ship. So that there is no dim sale, it's a sale. Then wash contract. Which are wash contract? Which are labor and work and labor and also goods are used. If all materials are used by the contractor, customer doesn't supply anything. There is no acquisition of the goods or material to the property of the customer. In that case, the property in the material does not get progressively transferred to the customer in the execution of the contract, or during the execution of the contract. It gets transferred only when it is handed over, after everything is over. So therefore, in this case, it may be wash contract, like question papers, currency notes, or bank checkbooks. It is wash contract, but not of the type to which 46th Constitution Amendment would apply. Similarly, photocopy. Of course, there is a ruling in SEC which was not necessary, but they have given, earlier two judgment ruling they have overruled, but I think that is not a correct thing. Because they are in photocopying, we are not interested in the paper, we are interested more in the image. So everything should be service. But if some material is used by the contractor and the other material are given by the customer, and there is a blending, value addition, what emerges at the end, that thing does not wholly belong to the contractor. There is something of the customer. So therefore, in such cases, property will get transferred to the customer while things get blended during the execution of the contract, in the execution of the wash contract. So this will be subject to this dim sale, concept of dim sale. Otherwise, there cannot be. Now, in this ruling, there are some conclusions which I think that are not correct, which I have listed, there may be more. Now, this court says there is no need to apply dominant nature test for interpreting the contract covered by Article 366(29)(a)(b). So that may be correct, but if by applying dominant nature test, if something is sale or something is purely service, you don't say make it fall under this 46th Constitution Amendment and then try to find out what is the dim sale. Now, what was the intention in that 46th Constitution Amendment where the states wanted to levy tax? In a wash contract, they could not levy tax because what was passing on is immovable. So this Constitution Amendment carved out certain segment out of that wash contract as dim sale. But in case of sale of flat under construction, the code is admitting ultimately it may result in sale. The contract is only for sale and it covers the entire scope, all the work. What is being transferred is the entire immovable property. Now here the code is trying to carve out dim sale out of sale, whereas the intention was to carve out dim sale out of wash contract. So something which is sale, you don't need. In fact, that time also the courts, the states were not clamoring for to levy sales tax, which is otherwise sale, but cannot be subject to sales tax like immovable property. So the legal fiction, this is the wrong way of carrying out, the reverse way of carrying out. It failed to appreciate the meaning of the expression tax on sale or purchase of goods. Under this trust transfer of property in the goods, the course of execution of the wash contract has been deemed to be sale. Where a person is selling, the goods incorporated have not passed on to the other person before sale. Everything will be passed on only after sale. So nothing is passing on at the time of construction. All transfer is taking place after the construction. Then it is immaterial that the flat buyer has no say in designing. Now this argument they rejected. With what logic? No logic. What was argued? That the flat buyer who purchases and is supposed to enter into a construction contract has no say about the design, about the nature, quality of the material, layout, plan, or it has no authority to supervise the construction. This is so what? It can still be worse contract. But what is the meaning of contract? Contract is a promise to be delivered. What is promise? What is the extent of promise? Construction. It's not only delivery of flat, it's a construction. If somebody is promising to construct and I have no idea about what construction is going on, then how can it be a contract, construction contract? If the contract to sell flat under construction is vast contract, there is no basis or mechanism. They say that vast contract starts from the stage when the contract is entered into. A multi-story building is a 20-story building. It is constructed up to 4th floor and you buy on 10th floor. You cannot say that the foundation is not for your flat. And how much has been constructed for that flat so far? How to determine? Law doesn't provide. There is no mechanism. In fact, there is a dictum that if mechanism fails, the law levy is not intended. So I think that this needs to be overcome by still larger bench. Till that time, this confusion will continue. So if one does not read history, or even after reading, I would say they have read history because there are many rulings and objects and decisions are produced in judgment. If you don't understand it, you or try to understand history, you have preconceived notion, then you are condemned to repeat history and you will continue to suffer this. So thank you very much. Any questions I can answer.
Any questions?
Good morning, sir.
Yes.
My question is something related to collaboration. And in most of the joint development agreements, there is a two-way arrangement. Both the parties are coming together. Two developers or two builders are coming together. One builder is already having certain rights, like land rights, and incoming party is joining hands and paying some entry level premium. And then both the parties are joining hands to jointly develop the property. Whether that kind of arrangement will be hit by 66EE.
In case of joint development, what you are saying, both parties are contributing, but one should be very careful. Is it a joint business or one party is giving some resources but sleeping, not contributing? He may contribute land and then just lend his name at the time of transfer, sign the contracts. If it is a joint conduct of the business, that means both parties are contributing to the decision making process. In that case, they are joint ventures, and one party does not render service to the other. Both render service or go to the market and share the revenue, share the work. So in that case, the revenue sharing will not be subject to tax.
But if the incoming party is contributing by way of entry level premium, like then the developer already having the land rights, and the developer has already carried out certain level of activities, and then a new developer is coming in, they are having joint development agreement. to carry it forward from that point of.
From that point, the collaboration will start. Joint venture will start.
Yes.
So that accordingly it will start.
It should not be hit by.
There is no service. Because,
And if they share the revenue, like their agreement or their understanding is that certain portion of the expenses will be responsibility of one partner, and certain portion of expenses will be responsibility of another partner, and they share the sellable material like a number of flats or area. In that situation,
so they may not share at the net profit level. They may share at a gross level, or there may be a separate expenditures at separate parties. But as long as joining hands, joint decision making is there, as far as jointness is concerned. So to that extent, there is no service one to the other. So there the revenue sharing at a gross level also will not be subject to service tax.
thank you.